One of the cases the court is going to hear this year is called Perez versus mortgage bankers. And it's a case about the process that an agency needs to go through when it's reinterpreting its regulations. We all know how a bill becomes a law, right? Congress passes it, the president signs it. We know, by and large, how agencies make regulations. For the most part, they propose it, it goes through notice and comment rulemaking, they make a final decision. But the next layer of the lawmaking process is what happens when an agency interprets its own regulation. For this, there really isn't as much of a process. The Administrative Procedure Act says that the agency doesn't have to go through full notice and comment rulemaking to reinterpret its regulation, basically leaving the agency free to reinterpret its regulation so long as it doesn't change the words that are in the law books. There are difficulties with this, though. The Department of Labor years ago decided that it interpreted its regulation, and it decided that mortgage loan officers, they're not entitled to overtime pay under the federal law because they are administrative officers, they're not normal employees. Years later, the Department of Labor reversed its position, decided that these employees are entitled to overtime pay. It had a big impact in the industry. The industry challenged this rulemaking, this reinterpretation. And they raised fundamental questions about the extent to which the agency can just avoid notice and comment and change their interpretation of the law. It's a very challenging issue, though, because anytime you interpret a law, in a way you're sort of changing its meaning. At the other end, though, the slippery slope is if you just tell an agency you can interpret things without going through notice and comment, what are they going to do? They're just going to say, we're not changing the words on the page, we're just reinterpreting them, and they can make a major change to the law without any notice and comment proceedings and the usual transparency and oversight. And so mortgage bankers, the Perez versus mortgage bankers case is really bringing this to a head and asking to what extent can the courts require the agencies to go through notice and comment rulemaking for so-called reinterpretations, or are we just going to leave the agencies free to creatively reinterpret regulations without any real public process? So the challenge for the court is to try to draw a line that respects both transparency, avoids bad incentives on the side of the government, and also avoids bad incentives on the side of industry.